Thank you so much, everyone, for staying with us on the program. I'm being joined now to get more perspective on the Supreme Court judgment and what this means, the implication, and all of the perspectives that have been drawn into the matter by Professor Agbo Madaki, who is a professor of law. Thank you so much indeed for joining us tonight. It's good to see you, Prof.
Yeah, thank you very much, Mr. Sheol.
Thank you so much indeed. Let's start. Are you surprised by the position of the Supreme Court?
I wouldn't say that I'm surprised by the position of the Supreme Court. You know, when the matter was filed and then the interim injunction was granted, I think it was simply a foretaste of what to come in the future. You know, because considering the sensibility of the matter, the nature of the matter, you know, the gravity of the matter, for the Supreme Court to have issued an interim injunction at the time it did, to my mind, it was a foretaste of what to come. So I'm not surprised at the final outcome by way of the judgment of the Supreme Court that was delivered today.
Senior lawyers like you disagreed on whether or not an expert could actually come from the Supreme Court on such a matter, that in fact the agency of government that was involved was not even joined in the case. I mean, do you see any inconsistency in terms of the procedure of filing cases or approaching the Supreme Court?
Well, you know, the Chief Justice of Nigeria is virtually the head of the Nigerian judiciary, so to say, and then the court has issued practice directive repeatedly, even in terms of the rules of conduct for judicial officers in the country, on the issuance of injunctions, especially interim injunctions or interlocutory injunctions, as the case may be. And usually an interim injunction will be granted in the case of extreme urgency, requiring the necessity to preserve the rest as the case may be. And if, and only if, it is that necessary and important to grant an interim injunction, which will actually imply not hearing the other party, then such an injunction could be granted. Otherwise, ordinarily, the principles or doctrines of interim injunction actually negates the principle of fair hearing as enshrined under Section 36 of the Constitution, because it requires that in determining the rights of every citizen or person or institution, you must hear both sides of the case or the authoring party. And that is why the life of an interim injunction usually is about 7 days. So it is not mute, or do I say an academic exercise to begin to x-ray that particular interim injunction that was granted.
In any case, who can challenge the position of the Supreme Court?
But then one would have asked, that was there real urgency? And was there a rest to be preserved? And if not preserved, that would have been destroyed?
For the sake of our viewers who may not get the idea of what a rest is, I mean, when you say was there a rest, what do you mean?
You see, is there something that can be preserved that if it is not preserved, would have been destroyed if you allowed the case to run its full gamut or its full length to conclusion? If that interim injunction was not given, if you ask me with the greatest respect to the judges, and I have the greatest respect for the Supreme Court of Nigeria, if you ask me that interim injunction at that particular time wasn't necessary, knowing fully well that from the onset, the Supreme Court was very determined to hear that matter speedily, which of course they have done. So all that would have happened was to simply order that, put the other party on notice, and then hear the motion on notice. And then if it is necessary, having heard both sides, then you may not issue an interlocutory injunction. To my mind, that would have been the proper thing to do.
Before we look at the other allied issues that the Supreme Court raised in the obiter, and yes, let's look at the meat of the matter. The Supreme Court now said, for the fact, the 200, 500, 1,000 Naira notes will be, the old notes will be valid and will be legal tender upon the 31st of December 2023. That trumps the position of the CBN and the directive of President Buhari. Give us in layman terms what this means.
You know, first and foremost, the question we need to ask ourselves is whether the Central Bank of Nigeria is legally positioned or empowered to redesign the Naira or put it in a legal term to withdraw any currency from circulation. If you ask me, my answer in that regard, that it's yes, especially if you go by the redundant and notorious Section 20 of the CBN Act, especially subsection 3 of it, that empowers them in that behalf. I mean, with the acquisition, with the directive of Mr. President, yes, that they can do. But if you look at that Section 20, subsection 3 in particular, it talks of giving reasonable notice. And if you realize, what the Supreme Court anchored its decision on is that absence of reasonable notice. What is reasonable in the circumstances? You are talking of a country of over 200 million. You are talking of trillions of nairas in the hands of Nigerian citizens, money earned by them, and then suddenly, in one fell swoop, maybe in a space of less than 2-3 months, you now come up with this policy and say, if you don't change it, and yet you have the door locked against them, the possibility and the opportunity for them to change this money for the new one simply wasn't there. Other than the fact that Nigerians were going to lose their hard-earned income, I can assure you that it means the right to life. The right to life as enshrined under Section 33 of the Constitution is already being violated, being threatened to be violated, as the case may be. And it is the duty of the law, it's the duty of the judges, it is the duty of the court not to wait until irreparable damages would have been done before, before taking action. And that's why the law is very clear that anyone who feels that any of his rights has been threatened, is being threatened, and likely to be breached, that you can apply to the court. So if you ask me, the notice was absolutely insufficient. And it has caused incalculable damage, not just to the economy, to the psyche, to the mentality, and to the health and the well-being of individuals and the
What
nation.
about the internment of that policy?
If you ask me...
Because, I mean, sorry, according to the president, he said, for economic reasons.
You don't throw away the baby with the bathwater. If the government feels that there's too much money in the informal sector, I mean, outside the banking system, is that the best way to go about it? I'll give you a classical example. So many years ago, the government of Nigeria set up toll gates at all major federal roads. Because of the palpable corruption that they were not accounting for that money, those toll gates were destroyed. Is that the solution? Why don't you plug the leakages so that this money can be recovered for the maintenance of the road? So if too much money was outside the banking system, it's not redesigning the Naira, there's a solution. Even though the part to do that is vested the CBN. I mean, the CBN, the law is very clear under Section 1, Subsection 3, that they will have that independence to manage the economy, the physical policy of the country in terms of the currency, as the case may be. Yes, they can do, but I think there would have been better way, of ensuring that this money outside the banking system will get into the bank. Because the primary duty of government is the well-being of the citizenry. And I think that any government policy that appears to be anti-people, antithetical to that purpose, it obviously must be a very bad policy. So if you ask me of the internment, my answer is that the internment is wrong. And that's why a lot of political reasons have been read to it. So do you considering
think that
the timing.
there are political exigency in all of this, or political reasons drawn to it?
If you ask me, the people in government, when I'm talking of people in government, be they elected, especially those appointed, the appointive offices actually tried to justify that nobody was going to buy votes this time around. They didn't mean so. They were very, very clear on it. So if that be the position, then I think the reason was more political than economic, if you ask me.
Do you think that the position of the Supreme Court today, in some way, either minimal or maximal, will impact on the independence of the CBN?
If it will impact on the independence of the CBN, it will be positive, not negative. The CBN Act is very clear that the CBN ought to be independent. So if you notice what have happened, CBN traded its independence. Traded it in the sense that even though they had consultation with Mr. President, and even though Mr. President gave the directive, if you notice, instead of the CBN to make the announcement, to give the notice, more or less it is Mr. President that was usurping the functions of CBN, if you ask me. It wasn't the duty or responsibility. That power was never seized to the president under the CBN Act or the Constitution, that the president could order an extension or could announce an extension. No.
My fear here, Prof,
yes,
is some of the decision and actions of the CBN is also already in motion, which counters the position of the Supreme Court as of today, that those notes should be in circulation up on the 31st. But CBN has said substantially it has withdrawn those notes out of circulation. What do you see any action that is contravening, that could contravene the position of the Supreme Court?
You see, the truth of the matter is that if decisions of courts, even be it the lowest court in the country, are not obeyed, it is an invitation to chaos and anarchy, and the system could implode on the entire nation. Once a decision is valid and subsisting, all persons exercising legislative, judicial, and executive function must obey it. And that's what the mantra of the rule of law is all about, the supremacy of the law above all other persons and above all other institutions.
Prof, so let me pause you for a moment. When we come back from a break, I would like to know the other part of the judgment on the position of the Supreme Court today in relation to President Muhammadu Buhari. The Supreme Court said that the president was in breach of the Constitution. Now, the House of Representatives Speaker is already speaking, and he says there will be some kind of tinkering on the laws that guide the action and the activities of the CBN. We'd like to get your views on that. But we'll come back from this break. That will be what we'll be focusing on. Stay with us. Thank you so much, everyone. Let's get back to the conversation with Professor Agbo Madaki. He's the Dean of the Faculty of Law at the Base University. Thank you so much, Prof, for your time tonight. There are aspects of the position of the stance of the Supreme Court today. We touched on the directive of the president. In fact, the Supreme Court also touched on the issue of the policy and on the restriction of how much a person or a corporate organization can spend. And the Supreme Court said the president was in breach of the Constitution.
Of course.
How do you describe that? And what are the implications?
If you ask me, that is the most interesting and most exciting aspect of the judgment that was delivered by the Supreme Court of Nigeria today. You know, money, by the definition of money, money is actually property. And over 20 years ago, I argued successfully in an enforcement proceeding that money is property before Justice Eko, when he was of the Benue State High Court. So money is property. And so if you look at it under section 44 of the Nigerian Constitution, dealing with the rights to property, you cannot unjustly deprive anybody of his property. The money belongs to you. It is your property. So nobody has the right to determine how much of it you can spend or how much of it you can withdraw at any given time. If you ask me, that policy directive, either from Mr. President, and I think in that case is the Central Bank of Nigeria, is not only illegal, but very much unconstitutional, very arbitrary.
Was there an indictment of the president? If the Supreme Court says the action of the president is a breach of the Constitution, is that an indictment?
Would I call it an indictment? Just like the Supreme Court itself, Supreme Court has had reason to say repeatedly that yes, we are the final court, but we are not infallible. We are infallible because we are the final court, as the case may be. Mr. President, yes, he has his body of advisors, but he does not have exclusive repository of knowledge and a president that knows it all. So he's bound to either make pronouncement or make policy decisions that may be opposite and contrary to the happiness of the larger majority. And that is why institutions and organs have been put in place, especially under the Constitution, like the National Council of State, which is one of the governmental body to advise Mr. President on policy matter. And then you also have the National Economic Council, which is also another organ of government to address Mr. President on issues of economic policy. And I think what may have happened is failure of Mr. President to draw from the pool of this expertise knowledge in arriving at the decision. So if you want it in terms of semantics and English, of course, it is an indictment of Mr. President.
So there are also far-reaching consequences so the Speaker of the House of Representatives released a statement today. What fascinated me in part of that statement was the last paragraph, which I'd like you to weigh in on quickly. He says in the last paragraph, while we anticipate action by the central bank, there is still a need to examine and understand how this policy intervention turned out in the way it did. The House of Representatives will exercise its authority to review the actions and inactions, the failures of law and procedure that set the conditions for this profound failure of public policy. This is necessary to ensure we take the right legislative actions to prevent future recurrence. It looks to me like an investigation of some sort. Or how do you read it?
No, even if you call it an investigation, the Constitution empowers the National Assembly, to carry out such investigation. And that is why for us as teachers, and the basic rudiment of constitutional law, when we teach the doctrines of separation of power, we also tell them that there's no absolute separation of power, because even the National Assembly can exercise partial judicial functions and also executive functions, as the case may be. Just like the judiciary could also exercise quasi-legislative functions, as the case may be. But let us not forget the fact that Section 4 of the Nigerian Constitution vests the legislative powers of the Federation on the National Assembly, which is bicameral, and the Federal House of Representatives is one of the arms, one of the chambers of the National Assembly, as the case may be. But the most important thing is that the Constitution is very clear that if they are making any law, it must be for the good governance of the country. So any law that is to be made must not be opposite and contrary to the generality of the interests of the people. And that is why we try to examine the relationship between the law and the society. If you are going to make any law and it's not going to promote the happiness of the larger majority, obviously it will be a bad law. So in view of the Supreme Court decision, on which side is the National Assembly standing? If the National Assembly is standing with the Supreme Court, and I think this is one moment the Supreme Court has given a judgment that is a reflection of what the society wants. But there's a reflection of what the society wants. So if the National Assembly is thinking of tinkering with the CBN Act, I would say that the primary consideration is the happiness of Nigerians and not to the contrary.
And it brings me to how I want us to anchor tonight, just in 30 seconds, because the Supreme Court is a court of policy. And this looked to me like another policy that has been delivered from the kitchen of the highest court in the land. In 30 seconds, if you can tell us, what do you think is the biggest lesson coming out of the judgment of the apex court today for the nation?
Number one, whosoever has been saddled with the responsibility by Nigerians to rule this country, you must act pursuant to the interests of Nigerians who have elected you, because you hold this power in trust for Nigerians. Even though Chapter 12 of the Nigerian Constitution is not justiciable, Section 12 of it is very clear that sovereignty belongs to the people. And if you look at it, the doctrine of lawmaking, whatever law the legislators are making, whatever executive function Mr. President is exercising, he exercises it on behalf of the people, because the people have donated that power to him by way of electing as Mr. President. So my final take of it is that whosoever exercises power in this country, be it judiciary, be it legislative, be it the executive, they must exercise this fairly and in the interest of Nigerians.
All right. Thank you so much. I've gotten
and exactly that is what the oath of office subscribed to by Mr. President.
Yeah. Thank you so much. I learned a lot from the Supreme Court judgment today. The fact also that absoluteness should not emerge from the decision of those who are involved. Thank you so much indeed. Professor Agbo Madaki is a professor of law and the dean of the Faculty of Law at the Bayes University. Thank you so much indeed for your time.
Yeah, sure. Thank you very much.
I appreciate your time.
It's a privilege.
Thank you so much.